Cut to the day video news. We're in Judiciary A1. 1 o'clock. It's going to start.
Well, you got a good experience. It's a better work and the policy. You also, now you get a better cross section. So it's a different yeah. Oh, he's the guy. Since his wife was upset, he's on the second floor. So I said, Dan, the only thing he's supposed to be able to he says, you got that. And that's how he thinks.
There's 3 of you. Are any of them being videotaped today? I don't know. Well, we happen to hear. Let me know which ones are. Sometimes they just audio. Like mental health is now doing audio. And I think that's my thing. The tape is 1/10 of the house. That's 1/3 of the house. Then I have so let's say it's cheap.
He said he signed us up. I signed. I'm sorry. I'll rank you. Say it again. I'm putting it in pencil right now.
This year, the 70 across the you know exactly like how she's having this, I know exactly
Jimmy. Jimmy, check your wall. I didn't get that close. I stayed next to Paul. I know. Jimmy, you know what? I was just down the office. You don't know what's happening. John I'll go up and rattle Ryan.
I think Scott's there and
I'm just banging on the door. I'm going to smack it.
because everyone's not being put.
Tell me, Scott said that.
Yeah, so I'm sorry about service. I was they were going to be like
Yeah, so I'm going to drop this up. I got another issue.
interviewing clients. So I developed like a real She's awesome. She knows everything. Yeah. She's awesome.
You know what? This is really what we need to get. I just want you to know the assessment
Michael, when he gets off the phone, the last
They're being very cranky security today. They won't let us go on the other side.
Oh, that's what it is.
You here for the day?
No, not for the whole day. Oh, sure, thank you.
So he can stand up and all these.
They have too many committees. So how they tell Yeah, we have a practice What's on the DAs here? I can't imagine It's so tight.
No, I don't think you can do that.
I know which one you
Good afternoon, and welcome to the hearing of the Joint Commission of the Judiciary. My name is Claire Cronin. I am the House Chair of the committee. To my right is Senator Will Brownsberger, the Senate Chair. So we'd like to all welcome you here today. Thank you for taking the time out of your very busy day to be here with us to discuss issues of which are great importance to you and to many members of the legislature as well. On my left is General Counsel to the Judiciary Committee on the House side, Keith right, to the far right, we have Jim McCarthy, counsel to the Judiciary Committee, Stephanie Fleming, Chief of Staff. Next to Stephanie on her left is Representative Dan Hunt. To his left, Representative Paul Tucker. We do have a lot of Dans in the legislature. Representative Paul Tucker, and to his left, Representative Michael Day. As we move forward today, you can see this is a very packed hearing room. We have a clock. There is a 3-minute limit for testimony. I ask that you really keep to the 3-minute limit. If the time comes where you will hear a bell will go off at 3 minutes, at that point I really hate to ask people to stop, so work with us on this. Please be respectful to all the people that are behind you in line to testify and keep to that limit. And we are now joined by Representative Carol Fiola as well to my left. By order of our rules, we generally take elected officials out of order because they have other places to be in the building as well as some of the members of the legislature. So, to that, we're going to get going, and could I please have Secretary Gunn?
Good afternoon. James Brown, Program Chairman, members of the committee.
Can't hear.
Oh, sorry. That shows an experience.
What it shows is that experienced people can miss the microphone.
Okay. I was a prosecutor for a long time. I was a defense attorney. There's been different things asked of police officers over the years. 20 years ago when I came in, police officers had a role that was very separate from what they're expected today. Today, they're really expected to interact with the community in a real fashion, to be out of their police cars. And I've seen a different attitude among police officers. As part of their community, every day, they get into situations with dealing with the best of society and the toughest of society. I think in the last 3 years we all acknowledge that the treatment of police officers has been colored by mistakes that police officers outside of Massachusetts have made.
Just give me feedback.
This bill, Bill 3539, which I'm testifying in support of today, is a recognition that police officers have become a target for those people in society that are taking out on police officers the frustration that they feel against what has gone wrong for them. Now, the main parts of 3539 are that if a police officer is assaulted, and in that assault, the injuries that they suffer are serious bodily injury, that there is a further punishment that would have taken place. And there's a minimum mandatory of 1 year in state prison or 1 year in the House of Correction. Up to 10 years in state prison or 2 years, 2.5 years. The other thing is 58A, which allows the district attorney's office to file to keep a person in jail pending a hearing. Now, 58A is the most important thing. We look to the district attorney's office to keep us safe. Under a bail hearing, the judiciary is only supposed to look at whether or not the person's a flight risk. You can be not a flight risk and at the same time be a danger to the entire community. Anger doesn't subside when you're arrested. You can walk out in that courtroom and still be ready to walk out and assault another police officer. If we don't have a bill like this that solves that problem, all we're doing is putting an angry person back on the street to assault again. I see my time is running out, but as far as the serious bodily injury that's part of this bill, what I suggest to you is that it's been said, well, this is just going to be used for the police to take bumps and pushes and protect themselves in that way. Well, that's not what's going to happen. You have to have an injury that's to the point of maiming or putting someone's life at risk before you can charge them with this bill. And that's going to keep that. It's going to only be used as a shield, not as a sword by the police officers. And that's why I think this is a appropriate bill under the circumstances that we live in. Police officers put their lives at risk. If there's any questions on that.
Thank you very much, Mr. Secretary. Do we have any questions?
You were just on 3053. Is that the right number? I'm asking about it.
3539.
3539. Okay, thank you. That was probably my experience.
Any questions? Thank you very much.
Thank you.
Could we have DA Ryan, Representative Linsky, and Representative Broder, please?
Good afternoon. I am here with District Attorney Mary Ryan, with whom I have the pleasure of working with for many, many years. And we're testifying in favor of a bill, House Bill 888, an act relative to the intimidation of witnesses and the interference with justice. This is a bill that's going to close a loophole from arising out of an SJC case, Commonwealth v. Hamilton. And DA Ryan will get into the specifics of that bill. And the intent of it is to protect witnesses and those involved in the criminal justice system. And I'm going to ask DA Ryan to get into this.
Thank you, Madam Chairperson, Mr. Chairperson. With respect to this bill, the loophole that this would close is that right now, someone being charged for threatening or intimidating a witness can only be charged if they are doing it prospectively. So if I threaten you today, don't go testify tomorrow, I can be charged under this statute. What happened in the case was a probation officer violated a probationer. The probationer then threatened him for having done that yesterday. And the court said the law does not apply retroactively and suggested that the legislature change that. I think this is a common sense fix. We clearly want people not to be afraid that they will be threatened the day after as well as the day before. I'm asking you to vote favorably on this bill and send it out to vote.
I too had the pleasure of serving with Attorney Ryan for a much shorter period of time than Representative Linsky, and I'm delighted to be here. Be a part of referring to this legislation. The first bill I want to talk about a little bit is, I don't remember, it's 3029. It's an act to protect the property of elders and disabled persons. This does a couple of different things. It establishes a crime of obtaining possession without consent for property of elders and disabled persons. It creates a penalty regime, creates importantly a heightened penalty regime for possession without consent where real property is involved. Importantly, it also has consumer protection features by saying essentially that governing the way that the transactions are done in terms of caregiver witnessing, and importantly, putting a prohibition in place whereby a caregiver cannot be a witness to a transaction where that caregiver would benefit. It also empowers a judge sitting in the criminal section to order the return of property as part of the disposition of the criminal case. And again, I will defer to District Attorney Ryan about the particular case of the city of Lowell that really put an exclamation point, I think, on the need for a passage of this bill.
And in that case, what happened was an individual who had sought for many years to buy a house from a neighbor in order to give himself a buildable tract. The neighbor had always insisted she would never sell to him, did not want that land without it. When she was in a nursing home 3 days away from death, attached to a morphine drip, unable to recognize anyone that she knew, that individual, who also was a city official, appeared in her room and had her sign the documents transferring that house to her. My office prosecuted that case. We secured secured a conviction. It was overturned by the Supreme Judicial Court saying that we had to establish that his knowledge that she did not understand what she was doing was subjective rather than objective. So just the fact that you saw someone on a morphine drip and they had previously said they didn't want to sell it to you was not enough. We had to show the subjective intent. We retried that case, secured a second conviction, but think that given that change, the court suggested that the legislative fix would do that, and a piece of this is to require that a caretaker be certain that the person signing any documents understands what they're doing. And secondly, allows, as Representative Broder said, one of the things, even after the first conviction, is the family couldn't get the house back. So it allows for that transfer back of real property. So again, I think this is a common sense piece of legislation that will protect our growing senior population.
One more bill. Though I will say that I kind of cheat a little bit. And I used to work before I became a member of the legislature in Health Protective Services. And I can tell you that this will be a critical piece of a tool to protect seniors. The number of incidents like the district attorney described are many, and the tools available to families to kind of unwind these transactions can be very long and very expensive. This will be a tremendous, tremendous help to those folks. Finally, we have an act to prevent child enticement. This is essentially a case that says, other than certain enumerated actors who you would not be surprised to learn their folks like first responders, law enforcement, police, it would be unlawful for an adult to entice someone 16 years of age or under into a motor vehicle. I think it kind of speaks for itself. And again, there are one particular case in particular that led the district attorney to take an interest in the matter.
This was a case that we prosecuted where a man tried to lure a young girl into his truck in a parking lot. She resisted. When we prosecuted, he was convicted. The SJC overturned that conviction, saying we could not prove whether he intended to confine her, rape her, or murder her, that we had to prove a specific intent. I think that makes no sense. I think we do not want individuals luring folks into a car when we cannot know what they were going to do, but we know it's not going to be anything good. And I think this legislation addresses that concern. And if I might, in 1 second, I am also here in support of House Bill 795, which increases the penalty for assaults on medical personnel. That is a growing issue, as you heard just a few moments ago from the Secretary relative to police officers. Certainly, folks in hospital settings know there may be occasional feelings running high and things happening. They should not be subjected to the kind of assaults we've seen recently, and then have them be only subject to a 90-day in the house. So we remove that mandatory sentence. We would create the option of charging a felony if the facts warranted. Again, I think this is something that we are in a position where we need protection. Thank you.
Thank you very much. Does anyone have any questions? Hearing none, thank you very much.
Thank you. Thank you for taking such a
Representative Rogers.
Thank you, Madam Chair. Mr. Chairman, members of the committee. First of all, I just want to say thank you for all the wonderful work you do. As former House Chairman of this august committee, I know how profound the responsibilities and how great the duties and immense the duties are. So I'm going to be very brief, Mr. Chairman, Madam Chair. For the record, my name is John H. Rogers. I represent 12 Norfolk House District, here to submit testimony in favor of House Bill 3591, an act relative to the use of EpiPens by police officers of Commonwealth. I can say on a personal note, as the father of 3 daughters, 2 of which have EpiPens all the time, that this issue hits home for me, like many parents, including yourselves, and those parents across the Commonwealth. However, that's not why I filed this bill. I filed this bill because I heard the story of my young constituent, a 2-year-old young constituent, Miss Piper Sullivan. So rather than submit my oral testimony today, Madam Chair, I would like to introduce my constituent who would like to submit brief oral testimony in favor of House Bill 3591. And for the record, it's Mrs. Chandler Sullivan is your witness, and she resides at 505 Washington Street, Walpole, Massachusetts. Madam Chair.
Thank you. 2016 will be a birthday that I will never forget. It could have been our then 20-month-old daughter's last day on this earth if it weren't for EpiPens. Piper had a severe anaphylaxis reaction while at daycare to sunflower seed butter, the alternative this day and age to nut butters. Her allergy was unknown at the time of her reaction. According to FAIR, Food Allergy Research and Education, approximately 20 to 25% of epinephrine administrations in schools involve individuals whose allergy was unknown at the time of reaction. We sent her to daycare with sunflower butter on her rice cake due to the fact that my son and I are allergic to nuts. What started off as a few hives around her eyes after ingestion, within minutes quickly became hives everywhere, swollen and itchy eyes, a small vomit, and wheezing. By the time the EMTs arrived, her breathing had become labored. Thank God for the Walpole EMTs as they administered an EpiPen and quickly transported her to the closest hospital. I'll never forget arriving at daycare, already having her being whisked away in the ambulance, not knowing right away if she was okay or not. I was quickly put into a police car and rushed to the hospital. I had no idea what to expect when I arrived. I remember going to her hospital room and not recognizing my daughter. She could barely see since her eyes were still severely swollen. It's an image that is forever etched into my head that I never want to experience again. While at the hospital, she needed a second EpiPen, along with steroids, Benadryl, and a full day in ER to ensure she was stable enough to be sent home and not admitted overnight. We learned that roughly 20% or more of people who experience anaphylaxis require a second EpiPen. Through this horrific experience, we learned that police officers, often the first responders to emergencies, are unfortunately not fully equipped or legally allowed to carry something so small and simple, yet so crucial for those affected by allergies. According to FAIR, once a serious allergic reaction in anaphylaxis starts, the drug epinephrine is the only effective treatment. Epinephrine, also called adrenaline, should be injected within minutes of the onset of the symptoms. More than one dose may be needed, which is the case for Piper. By not treating anaphylaxis promptly with epinephrine, it increases the risk of a fatal reaction. Upon learning that police officers in Massachusetts aren't legally allowed to carry or administer EpiPens, I reached out to a mom in Illinois who got a similar bill passed after losing her daughter to anaphylaxis. Annie Laguerre was at a friend's house for a back-to-school sleepover in August 2015 when she had an unknown anaphylaxis reaction to something. 911 was called, and the police were the first to arrive, but they were not equipped with EpiPens. By the time the EMTs arrived, it was too late. Annie would still be here today if the police officers who first responded were equipped with life-saving EpiPens. With approximately 15 million Americans having food allergies, of which 1 in 13 children are affected, many of you likely have a loved one whose life could be saved by this bill. EpiPens saved our daughter's life. Please vote yes for this bill. Thank you very much. Does anyone have any questions? Thank you very much.
Thank you, Madam Chair. Thank you, Mr. Chairman.
Representative Crocker.
Madam Chair, Mr. Chairman. I speak to you today on House Bill 749, which is an act relative to felonious assault and battery on a police officer, second offense. This bill will improve the ability of the court system to focus on individuals who have shown not only an inability to accept the rule of law enforcement, but for those who pose a threat to those dedicated to our safety, to the security of our communities. Chairman Brownsberger, Chairwoman Cronin, there is an unjust discrepancy when it comes to protecting our law enforcement personnel. Under the current law, it is a felony to harm a police canine or a police force in the performance of their duty. However, it is only a misdemeanor to assault a police officer in the performance of his or her duties. An assault on law enforcement is an assault on all the citizens of the Commonwealth of Massachusetts. For an assault on a police officer promotes lawlessness, and lawlessness puts us all in jeopardy. Furthermore, if the charge of assault and battery on a police officer, again, second offense, were to be upgraded to felony status, the probability the individual to be released on bail could possibly be reduced due to the severity of the offense, thus keep these potentially dangerous individuals off our streets and out of our communities where he or she could offend again before their trial. House Bill 749 would increase the penalty if convicted on the second offense from the current 2.5 years of incarceration to a maximum of 5 years. This doubling of the potential jail crime is exactly what this offense requires. Chairman Brownsberger, Chairwoman Cronin, it seems hardly that a week goes by that we don't hear of a police officer being badly beaten or even worse, as was the case very recently in New York City. I've been asked to file this bill on behalf of the men and women who protect our lives, too often sacrificing their own or endangering their own in the process. Stiffening the penalties against those who are convicted, again twice, of harming the bravest among us is something I am both proud and honored to do. In closing, I hope that the committee reports House Bill 749 out favorably and would be happy to answer any questions that you may have.
Thank you, and thank you for staying on the time period. Anyone have any questions?
It's 30 years of radio, I know what 3 minutes is.
Hearing that, thanks very much. Senator Ballard? Frost. Representative Frost. Sorry, I was looking for one.
Right, so what's happened before they die? Thank you, Madam Chairman, Mr. Chairman, members of the Honorable Committee. I'm Representative Paul Frost of the 7th Worcester District, and I'm here in support of House Bill 3053, an act relative to protecting police officers, and I also support the Governor's Bill 3539. I represent the town of Auburn. Just a little over a year ago, my hometown, my community was shocked when they woke up one Sunday morning to find out that one of our police officers, Ron Tarantino Jr., was shot and killed in the line of duty. In fact, in the very street that I live on. The community rebounded. It supported the Tarantino family. Some who are with me today, this is Ron's dad and his sister Caitlin. And in the aftermath came a call that we need to better protect our police officers. As already mentioned by the Secretary and by my colleague who just spoke before me, assault and battery on a police officer is only a misdemeanor. Yet, if you commit assault and battery on a firefighter in the line of their duty, it can be a felony charge. House 3053, which I sponsored with Senator Moore, Representative Kate Campanelli, and Representative Tim Lane, as well as many others, seeks to make assault and battery with bodily injury a felony charge. Chief Andrew Sluckus of the Auburn Police Department gives his respects and wishes he could be here today, but did provide written testimony which has been submitted to this committee. I will not read the entire thing, but just two things I want to bring up in his testimony that I think are fitting on this bill. The time has come for citizens in the media to realize that police officers are people too. Contrary to some public belief, we do not get paid to be punched, kicked, and assaulted. We get paid to protect life and property and to enforce the laws of this Commonwealth. All we want to do at the end of the day is be able to go home to our families and nothing more. Andrew Sluckus, when he was speaking at the funeral just a little over a year ago for Officer Tarantino, writes, "When I spoke at the funeral of Officer Tarantino, I said something good needs to come out of this. The passage of this bill would go a long way towards making Ron's death stand for something." I ask the members of this committee to just don't bury this bill. Please report something out, I'm willing to work with you. I'm sure the governor's office is willing to work with you. And whether it's a hybrid version of this bill, whether it's our bill, the governor's bill, or someone else's bill, I think something needs to be done. And there are folks out there who will say this is going to expand the powers of police. No, it won't. All it's going to do is send a message saying that if you commit assault and battery and you commit bodily injury, so it goes to that next level, that a DA can then choose to charge that person with a felony instead of a misdemeanor. And that raises the stakes when they go to court. So that maybe they won't be released. Maybe they won't go back out. Officer Tarantino's killer had 2 prior assaults on police officers before he decided to use a gun and assassinate Ron Tarantino. We've got to stop it before it gets to the point of deadly violence. And we should protect our police officers. We should protect our men and women in blue. And if they're protecting us, who's protecting them? And I say it's this body, I say it's this committee, and I say it's this legislature. And I ask you for your help and your support. Thank you.
Thank you.
There.
You can move the microphone.
There. Just wanted to offer all support of this.
Okay. Thank you very much. We're very, very sorry for your loss. Any questions? Thank you. Representative Lindsay?
Thank you for allowing me to come back. I'm going to be very brief on a very small bill that I filed, which is House Bill 284, an act relative to the penalty for disorderly persons. Under the current law, when someone is arrested for either being a disorderly person or disturbing the peace, the only alternative that a district court judge has in sentencing that person is a fine of up to $150. Generally speaking, the individuals who are arrested for that charge tend to either be homeless, they tend to have mental health problems, or substance abuse problems. I filed this bill at the request of a whole host of district court judges who asked the alternative to be able to place that person on probation rather than just be able to fine them. When you find someone, it creates a problem, particularly for this type of individual, of entering the cycle once again of unpaid fines, potential jail for paying fines, but it also doesn't address the underlying problem. District court judges, when they have this type of individual before them, would like to be able to place somebody on probation in order to maybe get the treatment, to have them have conditions of work or living, or maybe substance abuse treatment or mental health or medication that they can't do under the current statute. So by actually putting in a jail alternative, whereby the intent is not to actually sentence anybody to jail, but you need the jail alternative in order to be able to place somebody on probation with conditions, this would give the district court judges what they're looking for. It's a simple, common sense bill that really does close the loophole under the current statute. So this is a small piece of legislation, but we actually do think that it would give the court system the tools to be able to actually help the individual in this type of situation before them. So I'd ask a favorable recommendation on House Bill 84. Thank you.
Thank you very much. Any questions?
Thank you.
Thank you.
Thank you. Thank you for your consideration.
Chief Kais?
Mr. Chairman, Madam Chair, honorable committee members, thank you for this opportunity. My name is Brian Kais. I'm the police chief of Chelsea. However, I'm here this afternoon representing the Massachusetts Major City Police Chiefs as well as the Massachusetts Chiefs of Police on 9 particular bills that ensure the safety and security of police officers here in the Commonwealth. Specifically, House Bill 715 filed by Rep. Peters, titled an act relative to the penalty for resisting or interfering with a police officer as a 1-year misdemeanor.
House Bill 749, filed by Rep. Crocker, was up here earlier, titled an act relative to felonies. Felonious assault and battery on a police officer making a second and subsequent offense, a 5-year felony. House Bill 844, filed by Rep. Farrow, titled an act to increase the fine for harming a police plus or dog currently under Chapter 272, Section 77A, from $500 fine to a $1,000 fine. House Bill 915, filed by Rep. Nagel, an act relative to impersonating a police officer to increase the penalty from a current non-arrestable misdemeanor to a 5-year felony, and if the individual in question has a police uniform and is using a police badge, to a 10-year felony. Also, House Bill 2257, filed by Rep. Coppinger, and Senate Bill 938, filed by Senator Ross, both titled acts relative to assault and battery on a police officer as a hate crime, punishable under Chapter 265, Section 39, where there is an intent, where an intent to intimidate is involved. House Bill 3053, filed by Representative Frost, and Senate Bill 918, filed by Senator Moore, both titled an act protecting police officers, making the act of assault and battery on a police officer resulting in bodily injury to the felon. And Secretary Bennett was up here earlier, and we certainly like to support House Bill 3539 with the same language. And finally, Senate Bill 828, filed by Senator DiMacedo, titled an act relative to mandatory sentences for those committing an assault on a law enforcement officer with a firearm, to include a 10-year felony state prison sentence. Unfortunately, all too often we are hearing of repeated cases around the Commonwealth where police officers are being attacked and beaten on an ongoing basis. The current penalty of a non-arrestable misdemeanor, which is arrestable only as an ongoing breach of the peace, is simply inadequate and does little to provide a specific or general deterrent in preventing future attacks against those who are sworn to protect and serve. These bills will provide a giant step forward in ensuring that those individuals that choose to commit these assaults on police officers in the performance of their duties will be penalized accordingly, and will also help deter such future assaults on police. I truly appreciate the opportunity to speak with you this afternoon and advocate for these important officer safety bills, and would hope that you would consider voting these bills out of your committee for future consideration when the opportunity presents itself. Your consideration is greatly appreciated. Thank you very much.
Thank you very much, Chief. Any questions?
Thank you.
Thank you. Judge Harris?
My name is Leslie Harris. I am here on support Senate Bill 876, which is a bill that would decriminalize nonviolent and verbal student misconduct. I'm a former school teacher teaching 3rd and 4th grade, former probation officer, former public defender, former chief of the juvenile division of the Suffolk County DA's office, and I sat for 20 years as a juvenile court judge. I heard many of these cases. Many of them, in fact, 95% of them should not have been in front of a judge. We are criminalizing childhood behavior. The very behavior that when we were growing up was handled in school. It is disproportionately applied to inner city children, black and brown children. I've spoken in many towns across the Commonwealth, and I've asked those children, what happens if you get in a fight in school? Their parents have to come up to school. In Boston and other inner city towns, they end up in court for the same behavior. And that is not right. Our children need to be protected. Once you are arraigned in juvenile court, that record stays with you the rest of your life. There's no expungement in Massachusetts. So they have a criminal record, whether it's found guilty or not, it's on the record. And it impacts their lives forever. When we were able to meet with the school police officers, and we did a training about the impact of their arrest on children, the arrest rate went down. Well, we only did one training, and after a year or so, or 2 years, the arrest rate went back up. it is not proper to criminalize children for childhood behavior. And I just want to strongly recommend that we take disturbing the school assembly as a criminal offense off the books. Schools should deal with these issues, not the courts and not the police. We traumatize children when we arrest them. As a trauma survivor, I understand that. And I understand the impact it has on you for the rest of your life of being traumatized as a child. So I am seeking your support and praying that you will decriminalize childhood behavior by taking this bill and moving it forward. Thank you very much.
Thank you very much, Judge. Does anyone have any questions?
And I just want to recognize my friend James Cantwell, who was one of our district attorneys.
In previous session, actually, I think it was 2 years ago.
Who says the House and Senate don't work?
All right. We looked real hard at this, and I come at it from the same perspective. You don't want criminal justice involvement in situations that the schools should be solving themselves, no question. But as I spent a lot of time working on it, I came from being a strong proponent to being more or less neutral on this bill. And I'll tell you why, I'm just interested in your reactions. It's clear that in most of these situations, you know, this doesn't really happen until somebody gets at least a little bit physical. Not just back talk, you think that?
No, it's not just back talk. It's generally, it's back talk, it's being loud, it's making people come to the door to look out. And then it's how the school police officer approaches a child.
Yeah.
You know, we need to train our school police officers how to deal with traumatized children and how not to provoke an incident.
But no, see, and I totally agree with that statement. The question is whether the change in this law will really further that goal, because I think one of the risks that I came to feel was that it's a low charge, and that usually officers on paper have other charges available to them, and if they don't have that charge, they'll use another charge. So the real question, it comes back to what you just said, which is how do you get people to work problems out in a different way?
Yes,
And that became my greater interest. You know, it's a training issue and a school police contracts type issue and so forth. So I just want to put that out there. Those are some of the thoughts that are in my mind on this issue.
And I thought about that also, but the reality is that most of these children would not be arrested if that were not on the books, because there is no more or higher charge that they can turn to. If it's an assault and battery, and you have hit someone and hurt someone, if you kick someone in the head, arrest that child, because that child needs to come to court. But just yelling or screaming or refusing to leave a room should not.
It's a trespass, right? I mean, they've got other charges.
Well, it's trespass would be difficult because they have a legal right to be in school.
Well, if you're ordered off the premises.
Well, see, the problem that I had was you order a third or fourth grade student or a child needs transport, but that's what happens. To get out of the school, they have no way of getting home. And we still criminalize that behavior. Now, in high school, I agree, it's a little different. But not a lot. My big fear is what happens to children when they finish school and they have a criminal record.
Oh, of course. No, we don't want, we want to avoid the criminalization of it, but I'm just not sure whether this works to accomplish that goal. So there's a data question. There's a fact that there's a question about how it works. And well, I take your testimony as significant because I know you're on the front lines of it and you've seen some of these cases. Thank you.
Thank you very much.
Madam Chair.
Representative Campbell.
Madam Chair, thank you very much. And to address the Senator's question, and Judge, thank you very much for your testimony. I know there's legislation not to date, Madam Chair, so it'll take 10 seconds. I know legislation you have filed in response, and Chief Kais is here that we're trying to work on training school resource officers. So Judge, just to address another way of coming at this issue, you and I have talked offline, but I'd like to work with you and with the chief on the legislation to address training the school resource officers, perhaps to address that matter so we don't have arrests of things that could be treated in school. Thank you, sir.
Thank you. Lavinia Wiesel, Julia Dahlstrom, and Asia Graves.
I just wanted to thank the distinguished members of this committee for giving me the opportunity to speak. It is a very great honor. My name is Asia Graves, and I'm a survivor of child sex trafficking here in Boston. I was trafficked by multiple abusers up and down the East Coast for 2 years, from the ages of 16 to 18 years old. My traffickers kept me hostage and under their control. They forced me to prostitute myself repeatedly. I was arrested several times, not too far from where we're located right now during those years. All of those crimes were direct results of my trafficking. I would like to tell you that survivors of sex trafficking are not criminals. We do not belong in jail, and we do not have to be treated and have criminal records. We need support and care, and it would be, for me, I was greatly lucky to be able to receive help after I exited from trafficking. I would never have been able to testify in front of you if it wasn't for the support of people in this room around the city as well, including law enforcement. I am here today with some people from Ms. Levin, and I spoke with attorney Alex Zadig back in 2012 after I had been out of the trafficking situation for several years. This has impacted my life up until probably this past February. Landlords basically refused to rent to me. I had serious difficulty finding employment, and I was forced to change my majors after I finally entered college. I was determined to be a social worker. I wanted to give back to people who were like me, who had been in circumstances similar to me, as a way of giving back to my community. But unfortunately, due to having a prior arrest record, which went against good moral character in the state of Tennessee, no social work. You'll be surprised this even happens here in Massachusetts to survivors of trafficking. I didn't think I was going to ever be able to escape my past and start over fresh, but meeting with Alex Zadig and the people at Ms. Levin have given me that opportunity. Well, that is why I'm here today. You know, I thought that I would never be free of it. Alex and other attorneys at Ms. Levin worked with me for years, listening to me tell my stories and recant my worst possible experience, and they guided me through the complicated web of the court system. You know, they never gave up on my case. They kind of helped me even when I felt that I had nothing to offer and I was really stuck with my criminal record from the day that I died. When my convictions in Massachusetts were vacated last February, I was ecstatic and I finally felt I had control of my life. I was lucky to have the assistance of Ms. Levin and the associates there with Alex Zadig, and I have my convictions vacated. But survivors of trafficking shouldn't have to find exceptional, great, expensive lawyers, because I know that without their support, I couldn't afford like a $500 or $1,000 an hour lawyer, just to be honest with you. And, you know, I wouldn't be able to deal with this if it wasn't for them. And I'm finally out of able to move on. I'm currently studying for my LSATs, plan on attending law school to be maybe one of you guys. As well as I want to become an advocate for survivors like me and help them move forward and regain control of their lives. And please pass this bill so survivors like myself will be given a chance to do great things like you all do. And I really do thank you for your time today.
Thank you so much, Asia, and thank you for sharing your story. It's very difficult, I'm sure, but very impactful, so thank you for coming here today.
Good afternoon, Chairwoman, Chairman, and members of the committee. My name is Julie Dahlstrom, and I'm a clinical associate professor and director of the Immigrants' Rights and Human Trafficking Program at Boston University School of Law. Over the past 9 years, I've represented dozens of survivors of labor and sex trafficking in Massachusetts. And I'm here to tell you that survivors, like Asia, deserve a chance to start a new life. They should have their courage and their strength to find them, not their victimization. And for this reason, we ask that you vote favorably on House Bill 766 to establish a pathway for survivors of human trafficking to vacate past criminal records related to their victimization. When we hear about survivors, you often hear the words rescue and escape. But for most of the women and men with whom I work, the path towards a new life, towards exiting labor and sex trafficking, is not a fleeting moment, but a long, hard struggle. It's a road that will require them to relive painful experiences, to encounter stigma and shame, and to fight often unsuccessfully for a new life. They struggle to find work, to find affordable housing, and to find a place to fit in this world. And that's in part because, for many survivors in Massachusetts, their experience in the criminal justice system haunts them. It stays with them long after the trafficking ends. And I want to tell you about a former client. Let's call her Emily. She came to the United States at the age of 4 with her mother, and as a young teen, her life was turned upside down when her mother was deported. At the age of 18, she found herself homeless, struggling with mental health issues, and with a dangerous boyfriend who forced her to engage in prostitution. Instead of being seen as a victim, law enforcement charged her with sex for a fee and released her back into the hands of her abuser. And this happened repeatedly for a number of years until she met Sherry Jimenez, a remarkable survivor who runs the EVA Center in Boston. Sherry provided her with supports, but her criminal history stayed with her and really prevented her from finding permanent housing and employment, leaving her labeled a criminal, or even worse sometimes, a prostitute. She felt that even though she had come so far, she was stuck. The law and general attitudes about trafficking have evolved, and many of you have been a part of that. As you know, Massachusetts passed one of the most comprehensive trafficking bills in 2011, and we've come so far. But in this area, unfortunately, we are behind. Existing vacatur provisions are simply insufficient to address this issue, and 32 states have already passed vacatur provisions related to trafficking, including Connecticut, New Hampshire, New Jersey, New York, Pennsylvania, Vermont, Kentucky, and Oklahoma, to name a few. Our state was 47th to pass human trafficking legislation. Let's not be 47th to pass this bill. Thank you.
Honorable members of the committee, my name is Lavinia Weisel, and I'm a pro bono attorney at MOV295 here in Boston. And I'm here today as well in support of House Bill 766. Since 2010, as part of MOV295's pro bono practice, MOV295 attorneys, including myself, have represented survivors of sex trafficking like Asia who were trafficked in Massachusetts and across the country. We've represented them in criminal and civil matters, including in the sort of post-conviction relief proceedings that are the subject of this bill. And as you've heard, one of the many devastating consequences of sex trafficking is that victims are often arrested and convicted of prostitution-related offenses while under the control of a trafficker. And those convictions stay with them and create real barriers to housing, to education, and to employment. What's more, they carry the stigma associated with being labeled a prostitute. This bill is designed to remove some of these barriers for survivors by making it easier for survivors to petition the court to vacate prostitution-related convictions that were the result of the trafficking. This, in turn, will make it easier for survivors to gain meaningful employment and education and to move forward in rebuilding their lives. As an example of why this bill is needed in Massachusetts, I'd like to share with you the process that we've undertaken under existing law to assist one of our pro bono clients in vacating her prostitution-related convictions. She was lured into a life of prostitution and eventually broke free and even assisted federal law enforcement in prosecuting her traffickers. When we met this survivor, despite all that she had been through, she was struggling to complete her college education because the prostitution-related convictions precluded her from enrolling in a mandatory internship. At the time, our client believed that her only option was to seal the convictions. Instead, we engaged in a year-long process of moving to vacate her convictions under Massachusetts Rule of Criminal Procedure 30B. The process was complicated, time-intensive, and uncertain. The motion to vacate and related papers looked like this. They totaled over 200 pages with 9 exhibits and required more than 100 hours of attorney time. We were ultimately successful, but the process was draining and stressful for our client and would have been too expensive if we could not have represented her pro bono. The purpose of this act is to streamline this process. The act doesn't dramatically change the procedure for post-conviction relief in Massachusetts. Rather, it makes the process more accessible for a particularly deserving population. As Julie mentioned, 32 other states have recognized the importance of access to post-conviction relief procedures for survivors of sex trafficking. And with this bill, Massachusetts can join this effort to enhance access to justice. Thank you.
Thank you very much. Any questions? Representative Day?
Thank you, Madam Chair. I just want to say thank you to Attorney Dahlstrom and Attorney Wiesel for your advocacy and your frontline work in this area and how challenging it is. And just want to express my appreciation. And also to Ms. Graves, thank you for your courage in coming forward and testifying about the past and putting a face to the challenges that individuals like you, survivors like you, face in trying to put this chapter of their lives behind them. I appreciate it.
Any further questions? Thank you so much.
Thank you so much.
Attorney General Neal?
Good afternoon. Chairwoman Cronin, Chairman Brownsberger, members of the Strength Committee, thank you once again for the opportunity to speak with you as you consider legislation. Specifically today, I am here on behalf of my office's effort to support Senate Bill 858, which is an act to increase the penalties for corporate manslaughter. I want to start by thanking Senator Jen Flanagan, who's been a strong advocate for working people in our state and who has advocated for this bill with my office for many years. So as Attorney General, I have both the privilege and the statutory obligation of ensuring that our workers and our residents remain safe and that our companies play by the rules. Unfortunately, under our current manslaughter statutes, some companies responsible for really egregious actions have gotten away with barely a slap on the wrist. The current sentence for a person convicted of manslaughter is imprisonment for up to 20 years and or a fine of $1,000. In contrast, if a corporation, if a business is convicted of manslaughter, the only penalty there is a fine of $1,000. Now that fine of $1,000 was set in 1819. So obviously the corporation, there's no way to imprison a corporation. The recourse there is a fine. But the fine last set to punish a corporation for a manslaughter conviction was last set in 1819, which is why it is at the amount of $1,000. So this legislation would address that real glaring deficiency in the system. It's a law in desperate need of an update. Under the proposed bill, the fine for corporate manslaughter would be raised to $250,000 or more and would allow a company to be disbarred from contracting with the state for up to 10 years. The whole point when it comes to how we look at it, sentencing is a few different goals here. First, accountability. It's important that we have a law in place that actually works to hold businesses accountable for criminal violations. And in particular, we're talking about pretty egregious acts that obviously, if proven, result in the conviction of manslaughter. Secondly, that they deter bad conduct. That's another part of our system. And right now, a $1,000 fine is not an effective deterrence mechanism. And finally, as always, we want to have penalties that are actually appropriate for the crime, that actually fit the crime. And a law that sets a fine at $1,000 set back in 1819, in our view, simply isn't appropriate for addressing the crime of corporate manslaughter in today's world. Most importantly, I think we've seen even recently that we're talking about situations with real impact. If you think about the 2 drain workers who were killed not long ago, last October in the South End, if you think about the 77 people who died as a result of contaminated steroids, in the pharmacy case. If you think about even the big ceiling collapse of a few years ago in Elena de Valle, this is the nature of the conduct that we want to make sure is appropriately addressed through our criminal statutes. As you may remember, we've come real close in passing this in recent sessions and in reforming this law. In 2013, both the House and the Senate voted unanimously to amend the statute, but the bill fell short of reaching the governor's desk at the end of the legislative session. I hope that doesn't happen in this instance, and so it's why we're back today asking that it be prioritized and moved and favorably reported out of committee once again, so that we get a common sense bill in place, a law in place that will do what we need all of our laws to do. It's time to make sure once and for all that when it comes to egregious corporate action, it doesn't pay to cut corners, and certainly not when you're risking human life. And that's what we've seen too often, and that's what we want to make sure that we have the tools to appropriately address. So thank you as always for the opportunity to appear before you, and my staff and I are happy to answer any questions today or in the days ahead.
Thank you very much, General. Thank you for your hard work in this area. Do we have any questions? Thank you very much. Representative Garland.
Chair Cronin, Chair Brownberger, and the members of the committee. I will be very brief. I am available at your convenience to discuss this bill in detail. I am here to speak on House Bill 795. As a sponsor of the bill, I am present just to demonstrate my deep commitment and my strong support for this bill, and to let you know that I have been joined on this bill with 52 legislative colleagues. The problem this work bill addresses is workplace violence in healthcare settings, which is prevalent. 80% of the assaults that are perpetrated in the healthcare environment are perpetrated by the general public. Some assaults result in lost time at work, some in permanent disability, some in persistent issues related to post-traumatic stress disorder, some in near-death experiences, and we all know that there's some near-death experiences. Presently, assault in the healthcare environment of a healthcare worker is a misdemeanor. This bill makes it a felony. A misdemeanor under Mass General Laws under Chapter 94 is something like the sale of unfit coal. It is something like manufacturing and advertising butter imitations that are made with fat and oil. Today, a nurse, an EMT, an ambulance operator, a doctor, or any other healthcare provider woke up, showered, dressed, and left their young loved ones just like you did and went to work. Just like every single one of the people in this room. At work, they got assaulted. They were punched or kicked or bitten or maybe stabbed or maybe shot. Their health, their sense of self, their level of stress and now trauma in their workplace has forever changed. This is not part of the job, as I once heard a judge say. This is not a shame, as I once heard a co-worker say. This is a crime. And if it's not a misdemeanor, it is a felony. Thank you.
Thank you, Representative. Do we have any questions of the panel?
Thank you.
Thank you very much, and for all your hard work on this. Patricia Stewart.
I'm here on 3 bills. I don't know which one you want me to address at this time.
Your pick.
Okay. Very good. Take the one on top. My name is Patricia Stewart. I'm the Executive Director of Massachusetts Citizens for Life. And I'm here to offer testimony in support of House Bill 926, an act banning partial birth abortion. In the case of Gonzalez versus Lockhart, the Carhart rather, the Supreme Court addressed the validity of the federal statute regulating abortion known as the Partial Birth Abortion Ban Act of 2003. It found the act constitutional on its face for three reasons. It was not void for vagueness, it did not impose undue burdens of overbreadth, and it did not impose a substantial obstacle to late-term but pre-viability abortions. As explained more fully in my written testimony, a fair reading of House 926 demonstrates that it satisfies all these constitutional prerequisites. I want to just mention briefly the third prong of constitutionality, which is that House 926 does not impose a substantial obstacle to late-term or pre-viability abortions. In Gonzalez, the Supreme Court soundly rejected the suggestion that the purpose of the federal act was to put a substantial obstacle in the way of women seeking an abortion. Among the reasons it found amply justifying the regulation were the government's interest in protecting the integrity and ethics of the medical profession. Quote, where it has a rational basis to act and it does not impose undue burden, the state may use its regulatory power to bar certain procedures and substitute others, all in furtherance of its legitimate interests in regulating the medical profession in order to promote respect for life, including the life of the unborn. These same governmental interests and objectives in preserving and promoting fetal life amply justify the ban of partial birth abortion set forth in House 926. Following an example of 32 other states, and limiting the practice of what the U.S. Congress has characterized as, quote, a brutal and inhumane procedure, close quote, which had, quote, a disturbing similarity to the killing of a newborn infant, close quote, will say much about who we in Massachusetts are as a people. For these reasons, I respectfully request that this committee report on favorably House 926, and thank you for the opportunity to comment. Thank you very much. Does anyone have any questions? Hearing none, thank you very much. The other two bills, should I pass on those? Yeah, you are welcome to submit written testimony on that. Very well. Thank you so much. Michelle Matheson.
Good afternoon. I just want to say thank you once again for giving me the opportunity to come and speak to you today. I'm here about House 3131. On August 26th of 2011, my 20-year-old daughter, Amanda, was brutally murdered. She was stabbed several times, her throat slit. She was left dead with a pool of blood on the kitchen floor. Imagine my shock when I was informed that two of the officers assigned to protect the scene that night took photos of my daughter Amanda with their personal cell phones. These images were shared via text and email with over 20 different people that I'm aware of. Those images were also shown at a youth football game. The first officer who arrived on the scene that night stated he was in awe over what he had seen. Another officer was quoted as saying, "This is what I have to deal with at work." As he passed around his personal cell phone, showing off photos of my daughter Amanda laying in a pool of blood, as if that photo was a trophy. My hope today is that Massachusetts will pass this law, like our neighbor Connecticut has with Joshua's law. California has Nikki's law, New Jersey has Kathy's law. New York and Georgia currently have bills awaiting approval. This is a common sense law that should already be in place. It is my time to stand up and speak up for my daughter Amanda. She did not give permission, nor did I, or any of her family, to have her bloody body photographed and shared. It is time for someone to speak up and say that this is not acceptable. Our first responders have a job to do, and it should be done with respect and dignity to the victims that they are responding to. This is the last photo my daughter Amanda took of herself that afternoon that she was murdered. This is how I want her remembered. So please do not let this happen to another mother, another family, or another victim. In closing, I have worked closely with members of the Chicopee Police Department as well as Chicopee Comprehensive Telecom Unit. I have put together a training video that is 5.5 minutes long. With your permission, I would like to share that with you to view at a later date. Currently, this flash drive has been put, I've copied it 11 times, and currently it is being sent out to 11 different departments in Western Massachusetts. My goal is to get this out there and let people know that this is not acceptable. Unfortunately, I have seen those photos of the officers took of my daughter. This should not be happening. This should not, please, this should not be happening. A $2,000 fine and up to a year in jail might just be enough to say, don't do it.
Thank you very, very much. Thank you. I know how difficult this must be. But the reason you're here today is an important one. And on behalf of the committee, I would like to say I'm so sorry for what you have gone through and appreciate your willingness to come before us today. Does anyone have any questions? Thank you. Representative.
We'll take that.
At the end.
Thank you very much.
Thank you.
Fuller, Graham.
Good afternoon. Thank you for the opportunity to speak to you this afternoon in favor of S858, an act to increase penalties for corporate manslaughter. My name is Tali Graham. I'm the Labor and Environment Coordinator at NASCOSH, the Massachusetts Coalition for Occupational Safety and Health. We're a nonprofit coalition representing over 100,000 workers, unions, health, and legal professionals. Each year on April 28th, we release a report Work Memorial Day called Dying for Work in Massachusetts. And some of you have joined us out in front of the State House. We read the names of those who have been killed, injured, or made sick at work. And as we read the names, the 70 names of people who died last year, we were joined with many family members. And among them were the family members of Calvin Maddox. Calvin Maddox and his co-workers, as you heard previously from General Maura Healy, were working in a trench in Boston's South End neighborhood in October 2016 when the earth gave way. Nearby, a water supply line feeding a hydrant broke open. The hydrant caved in. Within seconds, the trench flooded with mud and the 2 men were killed. This picture is a worker across the street who vainly leaning down in the mud, holding a chain, came to try to see if he could help dig these people out as the water rose and rose. Just to give you the fire department said the flooded trench, which was 14 feet by 5 feet wide, lacked any safety protections. And just to give you a graphic sense of why these protections are life-saving, a cubic yard of earth, which is 3 feet by 3 feet, can weigh up to 3,000 pounds, or the weight of a mid-sized car. And that's what happened to these workers. And worse, on that site, there was an expandable trench box, but it was not in use, it was just sitting there. We do know that OSHA, they had a series of violations, OSHA violations, and then OSHA came back, and they had 18 violations pending. But the state manslaughter criminal justice was a tool that we were very, very pleased to hear about. And in February, Suffolk County Grand Jury indicted Atlantic Dream and the owner Otto on 2 counts each of manslaughter. And I just was reading in the Globe one day that the district attorney Conley alleged that Mr. Otto and Atlantic Drain Services willfully, wantonly, and recklessly failed to take the standard safety precautions that could have averted that tragedy. I won't explain the bill again because I think Attorney General Healy did a very good job of explaining why this penalty needs to be updated. And this is why MassCutch is here to support this bill today, to send a message to businesses that they cannot abandon health and safety. Thank you very much.
Thank you very much, and I apologize for mispronouncing your name. Does anybody have any questions? Thank you very much.
All right, thank you.
Mike Talbot, Larry Calderon, and John Nelson.
Michael is in New York City, so I apologize on his behalf, along with Detectives Benevolent Society and Spare Officers Federation, the FOP, Mike Talbot, they're all in New York. Also, like to recognize the Tarantino family once again, spending that time here today. My name is Larry Calderon. I'm the Legislative Director for the Boston Police Patrolmen's Association and a police officer in the city of Boston. I'm here today while many of my brothers and sisters are at a funeral for a New York City police officer, Mayasosis Familia, who was shot and killed in cold blood for the single reason that she is a police officer. I'm here giving this statement because what Governor Baker is trying to do may deter and prevent what happened to Officer Familia from happening to another police officer in the Commonwealth. We all know police officers have a difficult and dangerous job. But as civil servants, we put on the uniform because we have a calling to serve and protect our communities. But that same uniform has made us vulnerable. We are increasingly becoming a target of disturbed, harmful, hateful, and violent individuals. Crimes like this should have punishments. We can debate, how much punishment deters crimes, but we believe that the harsher the punishment, the higher the deterrent. I think it goes without saying that if you commit assault and battery on a police officer, causes serious bodily injury, you will be punished more harshly than just a simple assault. And Governor Baker's bill is the first step in making sure that that happens. It would allow the court to treat this serious crime as a felony and make sure the offender serves no less than 1 year of incarceration. Currently, judges are not required to consider whether individuals charged with this offense present a danger to the community. This bill would allow judges to consider whether a defendant who has been charged with assault and battery on a police officer is a danger to the community, and thus allow the judge to hold that defendant until pre-trial, so that he or she cannot be in the community to hurt someone else. I can tell you someone's life that could have been saved by this bill already. Last year, Auburn police officer Ronald Tarantino Jr., one of Massachusetts' finest, was shot in the back during a traffic stop and died from his injuries. His murderer had already been in and out of the court on various criminal charges and the time leading up to his murder of Officer Tarantino, including a charge of assault and battery on a police officer. If this bill had been a law at the time, the judge hearing the case could have considered whether the offender was a danger to the community and possibly issued a pretrial detention order. Instead, his charge of assault and battery on a police officer was a misdemeanor, so no dangerousness hearing took place, and the result was the shooting death of Officer Tarantino. If you worry that this law would be abused or used inappropriately, please have no fear. The defendant charged with this crime is not accused of pushing or resisting arrest. A defendant charged with this crime would have caused permanent disfigurement, caused an officer to lose a function of a limb or an organ, or something where there is a substantial risk of death. It is not fair to allow this type of individual to walk out of a courtroom with just probation. This bill prevents that from happening. There's a minimum 1-year sentence with a maximum 10-year sentence in state prison,
I hope you can all agree with me that a person that assaults a police officer for the specific reason that he or she is a police officer and causes serious bodily injury should be at least sentenced to 1 year incarceration. Someone who assaults a police officer acting in the line of duty is not your typical criminal. He or she is an individual who has assaulted and caused serious bodily injury to an officer who has sworn to protect others. He or she has no respect for our laws, our values we hold dear to society, and in other words, this individual is capable of much, much worse. We need to send a message to our communities that will not tolerate this type of behavior any longer, and we need to send a message to the police officers who protect and serve their communities that we respect and support them as well. I urge you to support this bill and change the process so that we can prevent more injuries and deaths in the future. In closing, I'd just like to remind the panel we're also in support of many bills that you already know about. Many of you have heard here today. House Bill 749, 795, 2257, 3053, and Senate Bills 829 and 938. Thank you very much.
Thank you very much. Any questions? Representative Tucker?
Okay, I just want to thank these panelists. They've been several times very strong advocates for the men and women of law enforcement. I appreciate what you do. Thank you.
Thank you very much, Representative.
Any further questions?
Chairman Brownsberger, Chairman Cronin, other distinguished committee members. My name is John Nelson. I'm president of police officer for 32 years here in the city of Peabody, and the vice president of the legislative committee, chairman of the Massachusetts Coalition of Police, which represents over 500 members across the state. I'm submitting written testimony favorably to this committee in the following bill, House Bill 3539, that's presented by Governor Baker. Massachusetts Coalition of Police supports the testimony that you've already heard today from Secretary Bennett and my colleague from Boston, Larry Calderon. Yesterday, I was in New York City and I attended the wake of New York police officer Familia. Last year, I was at the wake and funeral for Officer Tarantino. In their memory and others, the Massachusetts Coalition of Police respectfully request that this honorable committee vote this bill out favorably. Thank you.
Thank you very much. Any questions? Thank you.
Thank you very much.
Okay, I'm having a little difficulty reading here, but I have Jim Leonard, Mildred LaFave, Dan French, Lisa Thoreau, thank you very much. Hope I didn't butcher anyone's name there, but just had to read.
Chairman Brownsberger, Chairman Cronin, and other members of the Joint Committee on the Judiciary. I appreciate the opportunity to speak briefly before you today on the act decriminalizing nonviolent and verbal student misconduct. I'm Jim Becker of Somerville. I'm here today in my role as co-chair of the Social Emotional Learning Alliance of Massachusetts, a group of individuals and organizations that promote effective social emotional learning in our schools and communities. I also serve as Associate Director of Health and Technology for Education Development Center, a global nonprofit that's headquartered in Baltimore, where experts in behavioral and mental health promotion conduct research, develop programs, and provide technical assistance to help communities throughout Massachusetts and around the world. At SEL Mass and EPC, we appreciate the leadership of Senator Jalen in sponsoring the Senate version of this bill, and we appreciate also the strong commitment to the promotion of social, emotional, and behavioral health and well-being demonstrated by the chairs, co-chairs, and other members of this committee. The bill before you raises an important question. how can we best create safe and productive environments in our schools and communities? From the practical experience of our many SEL for Mass members, as well as through decades of research, we know the answer. Rather than focusing on punitive approaches, developing a collaborative, proactive system of supports that builds social and emotional competencies and fosters positive school climate can produce the best results. The National School Discipline Consensus Project, organized by the Council of State Governments in partnership with the Office of Juvenile Justice and Delinquency Prevention, produced a major research-based summary of the extraordinarily adverse effects of punitive disciplinary methods in K-12 schools. This report concludes that the combination of a positive school climate, tiered levels of behavioral support, and a partnership between education, police, and court officials can indeed contribute significantly to a decrease in youth arrest and referrals to the juvenile justice system. The report also cautions that punitive discipline for minor, non-violent offenses disproportionately impacts disadvantaged groups like low-income students, minorities, students with disabilities, and LGBTQ youth, and that student engagement with the juvenile justice system adversely impacts academic success and results in lower graduation rates and many other negative outcomes for these students. This bill will continue to trend in the community who are involved, taking a positive, proactive approach. We strongly support passage of SB 876 and urge you to report out to your group. Thank you.
Thank you, sir.
Thank you for the opportunity to speak to you today in support of House Bill 328. My name is Dan French. I'm the Executive Director of the Center for Collaborative Education, a nonprofit based in Boston that works with school districts creating innovative schools. I would like to share with you 5 research findings that support this important bill. 1, the presence of school police results in higher arrest rates in schools with no police. A 2011 study found that the presence of an officer in a school is associated with more than a doubling of the rate of referrals to law enforcement. Essentially, the presence of police tends to result in harsher measures of consequence, even for minor offenses, than in schools without police. They found no crime type in schools where there was police, no crime type resulted in decreased crime rates. 2, students are most often arrested for disruption, a catch-all phrase that does not include criminal offenses. The ACLU calls it criminalizing adolescent conduct. One prominent study found that the presence of police officers often redefines disciplinary situations as criminal justice problems rather than social, psychological, or academic problems. In fact, a Texas advocacy report found that out of 3,500 student arrests, only 20% involve weapons or violence. 3, school arrests disproportionately affect low-income Black and Latino students. Black students are more than twice as likely as white classmates to be referred to law enforcement. These disparities in school arrests are consistent with research suggesting that bias often plays a role in discipline categories such as disruption. Yet there's no evidence that racial disparities in discipline are the consequence of different rates or types of misbehavior by Black and Latino students on the one hand and white students. 4, school police are rarely trained to deal with mental health and disabilities, resulting in higher arrest rates. Nationally, students with special needs represent 26% of all law enforcement referrals, yet represent only 14% of the enrollment. If a police officer with no specialized training is called upon to deal with a student whose perceived misbehavior is due to a disability, they often view the student's behavior as criminally disruptive. And last, ultimately, school arrests have substantial negative effects on students' life trajectories. A study found that arrest has a substantively robust impact on dropping out of high school, as well as contributing to significantly lower rates of enrollment in four-year colleges. And yet we know that the consequences of dropping out of school are enormous. 68% of state prison inmates don't have a high school diploma. This bill puts reasonable and important measures to ensure that the school police play a helpful rather than damaging role in the lives of students with whom they interact. Thank you.
Thank you very much. Thank you. I appreciate this opportunity to speak before the committee. My name is Lisa Thoreau. I'm the Executive Director of Strategies for Youth. We're a national nonprofit based in Cambridge, and we work with law enforcement agencies across the United States, training law enforcement patrol officers and school resource officers. I want to make a few points in support of Senate Bill 876 and House Bill 328. First, it should be axiomatic that we do not want to arrest children, and we do not want to arrest them in school. A commitment to avoid arrest for defiance and disturbing lawful assemblies in school is the key strategy to stop youth going into the school-to-prison pipeline. As multiple reports have shown, as various empirical data have manifested, including data collected by Citizens for Juvenile Justice in Massachusetts, the school-to-prison pipeline is flowing in Massachusetts and disproportionately funnels Black and brown youth into the juvenile justice system. Under Massachusetts law, let's remember, you can arrest a child as young as 7. Is it truly in the interest of the schools or the police, much less public safety, to arrest children that young for expressing verbal or nonviolent acts of defiance, much less their elders? Secondly, I want to point out that the statewide opposition of major Massachusetts police organizations to this bill is nothing short of startling. The International Association of Chiefs of Police, IACP, strongly supports the reduction of use of arrest for all nonviolent verbal disciplinary issues. Indeed, IACP's report on recommended policies and practices for policing youth states 3 conclusions. First, school completion must be a central goal of school safety, discipline, and truancy policies. 2, it is indispensable to achieve positive outcomes for individual youth and public safety as a whole. And 3, the public must ensure that law enforcement presence in schools does not contribute to school-to-prison pipelines and that policies and practices do not lead to disparities based on race or ethnic background. That is what's happening right now in Massachusetts. And the adoption of policies to not allow arrest have been engaged in Los Angeles and Philly without an increased level of arrest or disorder or mayhem. Massachusetts is traditionally a leader in education reform, and yet here, while we're supporting trauma-informed practices by teachers, we're promoting also and allowing trauma behaviors by law enforcement. This is not helping. Trauma typically is experienced by children at the hands of adult authority figures. We are not doing very much by allowing authority figures in the schools where they're allegedly to promote relationship building with youth to have this power over them for simple verbal disciplinary acts. It is in no one's interest to actually harm strong police-youth relations. I'd be happy to give a copy of my full testimony to the clerk.
That would be very much appreciated. Does anyone have any questions? Representative Tucker?
Thank you, Madam Chair. I'm not sure if you heard earlier, we had a distinguished jurist here, and Senator Brownsburg had a bit of a back and forth. And if I could just paraphrase what the Senator said, is this an issue of the need for decriminalization, or is it more a need for proper selection, training, and de-escalation? From some of the statistics you quoted, and I don't want to put words in mouth, but it almost seemed that you feel that police officers should not even be in the schools. Am I reading that wrong?
Well, ideally, you probably should not need police officers in schools, but if they are going to be in schools, it is an issue of training. That too often what happens is that the regular disciplinary issues become the domain of the police, and that should not be the school police officer's role. The role should be to hold the culture defined by the school and deal with serious offenses. So yes, there is a huge issue of training there, and this bill would help solve that.
We actually to retrain SROs around the country, including Massachusetts, and training is key. And Representative Cantwell proposed legislation in the last session to ensure that there would be both training and funding for it, and the funding led to its demise, I believe. But training is key. I just had the pleasure of training the Boston School Police last week, 2 weeks ago, and I realized that not a single one of them had learned anything about special ed law IEPs, nor are they involved in conferences to know how to have the proper responses to children with IEPs. They will use these laws, and they're often pushed by principals to use these laws. So this bill is very important in 76 because it also addresses the need for MOUs, which will structure the relationship between police and schools, if they are to exist, and clarify what those roles are. But if you leave this on this book, on the books, it will be used, and we know it is used. When I was in Springfield in 2010, there were 6 felony arrests. 96% of the remainder of the arrests were disturbing a school in assembly. They were not assaults. They were not taking your hat off. They were running in the hallways. They were talking back. They were banging on the front door to get in.
Thank you, appreciate that. I just wanted to say the last time we had Cambridge Police, and they seem to get it right.
They do.
Yes, something we could take a look at. Well, thanks very much.
Representative Fowler.
Thank you, Madam Chair. Thank you for your testimony. Perhaps the committee has it, or you could provide it. How many arrests are we talking about by grade in Massachusetts each year? That would be helpful to me to see the incidence of it. Additionally, I have to tell you, in my community, I live in Fall River, we really have a great relationship with the schools and the SROs. They're looked at as great community partners. They're attending the sporting events, and they're actually there should there be other questions. So I'm not seeing a high incidence of arrests in the schools, and maybe you could highlight those numbers to us and perhaps bring to the committee.
I would like to say that the next panel coming to discuss this has that data, but that data is very hard to collect in Massachusetts. Not all schools report it, not all schools disclose it accurately, and the state ed department doesn't seem to always have the ability to ensure its accurate collection. And I will say that I see huge variation within the state of Massachusetts by school district and police department in the use of arrest as a tool of ensuring order and discipline in the public schools. So I refer you to the Citizens for Juvenile Justice report written on this topic, the name of which is escaping me right now, but it is the key report that has led to the Department of Education and Department of Justice overview of certain cities in Massachusetts for their extreme use of disturbing a lawful assembly arrest rates. And I can get that to you, the link.
And the important thing to note is that the majority of arrests, as was noted, are for disruption, school disruption, which should not be a criminal offense. And that's where the absolute need for training comes in. We should, knowing that any kid who gets arrested, as we've heard today, gets a record that they can't expunge. Why would you move from a simple issue of disruption, and certainly rudeness, whatever it may be by a student, to then impacting their life in a very significant way?
Thank you very much. Thank you. Colleen Shea. Lisa Gerson. Daria.
My name is Colleen Shea. I'm an attorney and a stand fellow at Disability Law Center here in Massachusetts. I represent low-income students with disabilities in school discipline matters across the Commonwealth. A few of my clients are interested in coming to testify today, or clients' parents rather, but unfortunately they were unable to make it due to jobs and other commitments. But I would like to share a few stories I think highlight this issue and sort of demonstrate the need for all the various things that this bill is going to address, which is the MOUs to delineate the clear lines between everyday school discipline and when there's a need for a police officer to come in an emergency training, and also taking those minor offenses off the books for school disturbances, and also the reporting component, because as we just heard, the data is not being reported out, and right now we're not really sure, which communities
are overusing this tool with the SROs. I also wanted to note that this isn't a problem in one community or another. I have just started this job in September, and I have clients from school districts all over the state. I testified a month ago. I picked up another client who was arrested at schools, middle school. And just to list off some towns, Middleborough, Neshoba, Palmer, Randolph, Nantucket, Pittsfield, and Boston. Just to give one particular story that I think really addresses this, the new client that I got last month, 14-year-old middle school student with ADHD, oppositional defiance disorder, and anxiety. He's engaged in a pattern for years of bolting and throwing objects and cursing when he becomes dysregulated in school. He has an extensive behavior plan to de-escalate him. In June, he became dysregulated and started sort of just throwing cardboard boxes on a wall, not towards anyone, they were thrown in the hallway. Before special educators even had a chance to utilize his behavior plan and sort of calm him down, the school resource officer arrested him. He resisted arrest. They charged him with disturbing assembly, disorderly conduct, and resisting arrest. He was taken from the middle school in handcuffs in the back of a police car. This is the type of thing that I'm seeing all over the state. And it's, I was also a former 7th grade special ed teacher, and this is the age of a child that I would have in my classroom. And to me, this seems like such a simple thing that you would be able, with an effective behavior plan, to really calm him down and re-engage him and have him finish out the school day easily. And so then to sort of re-traumatize a student like that and put them through this whole ordeal sort of unnecessarily, because there was a clear delineation between school officials and police